Why don't we go ahead and get started? Yeah, okay. We're gonna run this like a workshop, so, if we've got questions, just feel free to ask them. And, give a comment you wanna make, feel free to make them. This is not the first time we've done this seminar. I don't know, maybe y'all have been to one of our successor trustee workshops we did in the past. But it's been such an important part of the practice that, we just felt like we needed to do another one. And, it's just so important to have the right trustees because you can have a beautiful plan and hopefully you've got a beautiful plan that we did for you. But if it's not done right, if it's not if the trustees don't follow your instructions, then it's all for naught. So it's very important that the trustees know what their job is and know what they're supposed to be doing, and also knowing what they're not supposed to be doing. And so that's extremely important. So we thought we'd do this workshop again, and also we haven't introduced Lindsay Tide to all of you. Lindsay's our new probate attorney, and she does litigation for us, and she's as well as estate planning as well. And so they have her own team.
Yeah.
And
we're just doing a lot more administration now than we used to. We've just been doing this for over 50 years now. And so I know some of our clients, and you guys have been with us since the early 90s. And so we are now having just doing some more administration and going through that process. We're just seeing a lot of commonalities of some misconceptions of what trustees think that they can do or what they should be doing. And so we just wanted to kind of bring the conversation to life. This is like Richard said, the conversation. So we've got some slides just to kind of guide the conversation, but if you've got questions, and we're going to throw some stories at you, some good stories and some horror stories. Hopefully I'll learn something together today.
well, there's been so many changes recently and in the past as well. I had a lady the other day brought in her trust that we did in 1992. And she said, is there any changes I need to know about? Well, there's been a couple changes, you know. So there has been a lot of changes. And the most recent change, I guess some of you have heard, the federal state tax exemption is now 15 million. I don't know if y'all knew that or not. Per person. So if you're married, then you can have $30 million tax free if you do good planning. Now, a lot of people don't do good planning, so they may not get past that full amount, but at least for single people, you can get at least 15 million. And with proper planning, you can get 30 if you're married. So that really causes a lot of people who don't have 15 million and maybe never will have 15 million to maybe reconsider the way they plan, because in the past we did a lot of planning to take advantage of those two federal and state tax exemptions, and a lot of people don't need that anymore. So sometimes a lot of people want to simplify their plan, and that's one way to simplify it if it means looking at it again. So we encourage clients to call us and say that let's do a review and see if there's anything I need to look at, that maybe I can do things a little bit better. And so I think that's important. So the key to this slide is that a lot of people have been told, unfortunately, there's been lawyers that would sell living trust and they'd say, do a living trust, and then when somebody dies, you don't have to do anything. And they were selling documents, because that is absolutely not true, because there are things that have to be done. And you just because you have a trust doesn't mean there's not things to do. Trust can be a very effective tool for handling your affairs, as opposed to a will plan that goes through probate and has all the requirements of going through wills, going through the probate process. Trusts don't do that. They don't go to the courthouse, and we don't do things before a judge. But the Texas Trust Code and the Estates Code says there are things that you have to do. And the main thing we'll talk about here in a minute is that trustees need to follow the terms of the trust. And that's very difficult for a lot of trustees. Children who are handling their parents' estate after they pass, it's, a lot of them have their own ideas about how things should be done, and they want to do it their way rather than the way the trust says. Mom and dad really didn't mean to do it this way. Well, they did, or else they would have changed. So it's very important that, that we follow the terms of the trust. So the objectives today really are just, we just want the trustees to understand what their duties are. What's your job? And then, there's gonna be some common mistakes that a lot of people make and we continue to make. We'll talk about those and we'll learn what we should be doing and what we should not be doing. So, yeah. So, going back to that original talk, probably when we did your plan, we talked about what the purpose of estate planning was and why we were doing it in the first place. Most people want to control their property while they're still alive. They don't want to have to die before things are being managed. And they want to take care of themselves and their loved ones should either one of them become incapacitated or disabled. They want to give what they have to who we want, when we want, how we want, and we don't want to do all that at the least possible cost. We don't want to pay lawyers any more than we have to. We don't want to pay court costs, and we don't want to pay estate taxes that we can avoid. That's a pretty general definition of estate planning. I think everybody can kind of agree that that's what our plan was, but implementing it and making sure it happens sometimes is a different thing. So, in a trust, most of you know what a trust is. Some of the successful trustees may not be as familiar with it as the ones who have the trust are. But there's 4 basic parts of a trust, different players in the trust. You have the trust maker who created the trust. Sometimes they're called different things, a trust maker or a trustor, or they got a lot of different terms. You can pick up a trust and somebody else did. They may call it something else. We call it a trust maker because that's what they did. They made the trust. So that's why we call it a trust maker. Then you have the trustees. Trustees are the managers. They're the managers of the trust. And usually it's the person who made the trust that become the managers. Sometimes the manager of that trust can be a child or a co-trustee who helps the maker. So sometimes parents, as they get along later on, they may want a child to be a co-trustee with them just to take care of business so I don't have to do it. Maybe we don't want to wait till we become incapacitated before our child or successor takes place. Maybe we'd like to have them on board now. So a lot of people do that. And sometimes it's a great idea. Sometimes it's not a great idea if that person decides they need a new pickup, or needs to take a trip or something. So you got to have somebody that you really trust. And we'll talk about that in a minute. But sometimes it's a good idea to have a co-trustee. The successor trustee is the person who takes over for the one who can't. So if you have a trustee, maybe it's a parent, they can't serve anymore, the successor trustee takes over. And that can be during incapacity or death. And then we have the beneficiaries. And they're the ones who receive the trust assets while the death of the trust maker. Got a question? Okay, it's okay. Interrupt me if you do. It's okay.
All right, dumb question.
There is no dumb question.
What's the difference between a trust and a will?
A will is a legal document that is authorized by the Texas Probate Code. And it's a document that typically passes your property to your beneficiaries. It's a document that has legal requirements that you actually file in the courthouse when you don't file it, you're dead. But your executor will file that in the courthouse and the judge approves the way you said you want your property to pass. And a trust is a private tool. It's a document that you create that has rules and instructions in it that says that this trust, I call it a big bucket. Okay, that bucket, we put our assets in the bucket, then we have managers of that bucket. And then we have rules and regulations about what happens with that. We say that if I become incapacitated, this is what happens. If I die, this is where I want the property to go. I don't want some judge to oversee what I'm doing. I don't want to have to go to court and have the rules and regulations of a will that takes sometimes months and months and months and months to go through that process. I don't want to fool with all that. I want to get the assets to where I want it to go, but I don't want it to be complicated into that system. And I like to pass it. Most of you all have trust where we pass property to our children and they actually get to keep it because we leave it to them in trust. And so they can manage, usually they manage it themselves. And that way they don't lose assets to predators or ex-spouses or bankruptcy or anything like that.
So you shouldn't have both?
Well, you do. So if you have a trust, you have a will too. Because remember I said it's a bucket, put all your assets in the bucket. But what if you die and you left something out of that bucket? There's a bank account that you forgot about. It's got some money in it. And it's in your name and it's not in the trust. We have a will that says, oops, I left something out of my bucket, take it and pour it back in the bucket. It's called a pour over will. Now you gotta go through probate to get that asset that you left out into the trust. I call it the spare tire in your trunk of your car. You never want to take that spare tire out ever, right? But if you ever have a flat, then you can keep going. Unfortunately, about 2 weeks ago, I had a flat on my car. The first time I've ever taken that spare tire out in 20 years of a car. I had to actually change the tire. I got my grandson to do it. So he changed the tire. Yeah.
If you're gonna talk about this later, we'll skip it, but what's the difference between a revocable trust and an irrevocable trust?
Irrevocable trust you can't change. A revocable trust you can change.
Say again?
A revocable trust you can change. An irrevocable trust you can't change.
Gotcha.
We use both. That they have completely different purposes, and we use irrevocable trust a lot of times to avoid taxes or to avoid creditors or to make sure property gets given to people where they don't lose it. So we use those quite a bit. Everybody here, pretty much, they have what's called a revocable trust. Okay. Now, when you die, that revocable trust becomes irrevocable. You don't want somebody changing your plan after you die. Just like if you have a will, nobody's going to change your will after you die, so you can't change the trust after you die.
Yeah, but when you have two makers, husband and wife, and the wife dies early before the husband does.
Yeah.
So it's not revocable.
Sometimes it is, and sometimes it isn't. Depends on how you set it up. Sometimes people set them up where the surviving spouse can't change things, and sometimes we set it up where they can change anything. It just depends on how it's set up. So there's no one way to do it. There's a lot of different ways to do it. So if you don't know how yours is set up, we'll be glad to talk to you about it. Look at it and see.
But for the people in the room who are not our clients, your parents are our clients, that the main reason usually that people are doing a trust is because they don't want to go through that court process. They want to keep things private and they want it to be on our timetable, not the courts. So that's probably the main selling point of why people are choosing trust over wills. One's not better than the other. It's just really what kind of administration you want your family to go through in order to get those assets to be able to go.
I don't have any here, but I wrote a book on estate planning made simple in Texas. It's on our website. You go to our johnsonfirm.com, go to our website, look at our books, and there's a book called Estate Planning in Texas Made Simple. And it talks about wills and trust. I mean, it says one's not any better than the other. It just one may fit your situation better than another. There's some people that a will is much better than a trust. A lot of people's trust is better than a will. You can't say that a hammer is better than a screwdriver. Okay, sometimes it is, sometimes it isn't. Okay, if I'm trying to screw something in the wall, I don't use a hammer to knock a screw in. So it just depends on the situation. So if you want to read more about that, it's just take you 15 minutes to read. So it might be something you might want to take a look at. But the successor trustee just steps in when somebody can't serve. Mr. Aaron.
Living trust is a irrevocable trust.
Well,
Revocable, changeable.
a living trust is just terminal. It's just terminal.
Yeah.
You can have a living trust that's irrevocable. Okay, a living trust is one created during your lifetime. Okay, and you can have it where it's irrevocable, or you can have it where it's changeable. Actually, technically, an irrevocable trust is a trust that something about it cannot be changed. So there's some irrevocable trust that can be changed. Okay, but there's something about it that you can't change. And that's what it is. Trustees.
When we're talking about living trusts here today, mostly everyone in here probably has a living trust unless you're doing Medicaid planning, which we can be revokable for that. But you can change it. Usually the surviving spouse can change at least the community property that's in the trust when one spouse dies. Maybe they can change everything. It just depends when you look at your documents just to see how y'all set it up when it was originally created.
So the successor steps in when the original trustee can't serve. Okay? And what they do is they take over the management of the assets. And they administer the trust according to the terms of the trust. Extremely important. Okay? It's not, they don't administer the trust the way they feel like they ought to be doing it or the way that they think mom and dad really wanted it to be to do it this way. No, no, no. You got to look at the document and see exactly what it said and you administer it according to the trust terms. The Texas Trust Code says you don't have, if you don't want to do a will, you don't have to do a will, you can do a trust. But if you do a trust, you got to follow the terms of the trust. So there are rules that you got to go by. So different types of trustees, you got a co-trustee, like I said, if somebody wants to have a child or a family member or a good friend for that matter, serve as a co-trustee to help them out managing things, you can do that. Husband and wife are co-trustees if they do a joint trust. Then you have a successor trustee upon incapacity or successor upon death. And then a lot of times our beneficiaries can be the trustee of their own share. Sometimes the beneficiary is not the trustee. You have somebody else managing it for a beneficiary who's not good at managing assets. You can also have an independent trustee for different purposes. So there's different types of trustees.
Sometimes when parents pass away and one of the children is named as a trustee, and sometimes they may feel overwhelmed and they're like, I don't know that I can do this all by myself. If the trust allows it, most of your trusts do, they can name a co-trustee, maybe another brother or sister, to step in and help them with some of those responsibilities. So that is an option if they want to share the responsibility.
Then does it have to be a formal appointment of co-trustee?
Yes,
Yes, it does.
Or can they just say, hey, I need some help?
No.
Well, it depends. It depends. So they can help by, getting information, but they can't be the point of reference. They can't sign on documents. They can't talk to institutions. Maybe they can, go through the garage and sign papers, but they're helpers. But they're not, they don't have any legal authority to make any sort of decision regarding the trust assets if they're not a co-trustee. So I see that a lot where they want to name it.
So who should you pick as trustee? Should you pick the oldest child always? No, because the oldest child may not be the one who's responsible, okay? You pick the one who's most responsible. Sometimes that's the youngest child, okay? May not be a child at all, maybe somebody other than children, maybe somebody totally different. But you want to pick somebody who's responsible. They got to be at least an adult. You got to be able to make a contract. You got to be 18, make a contract. You got to have somebody who holds your confidence, your full confidence, and they must be mentally confident. You don't pick somebody who's got issues or mental problems or not able to make decisions. Somebody that will follow your instructions that you give to them in writing. They're going to do what you say to do, even though it may not be what they would do, but they're going to follow your instructions. Somebody can make a decision. We've had people come in and they just can't decide. They just can't decide what to do. Even though the document says to do this, they say, well, I don't know if we're going to do that or not. Well, you don't really have any choice. You have to do it, but there are some people that can't make a decision. Somebody who can act impartially. You got this favorite nephew that, I love them all, but this was my favorite. I'm gonna make sure they're taken care of. I'm gonna make sure that they're treated differently, but you can't do that. You have to treat everybody impartially. If you're gonna take the job as a trustee. Sometimes we need a professional trustee if our family members aren't mature enough or are capable of being a trustee. Doesn't mean we don't love them. It means that maybe they're just not capable of serving. then we can bring on, a professional trustee. And that makes sense in a lot of cases. And sometimes what we do is we bring on a professional trustee as a co-trustee. So we have a child who's maybe meets most of those definitions, but they just need some help. And so we can have a professional trustee serve with them.
What happens, run that there again. Like that, someone who can't make decisions, what happens?
You know, then you got a problem with them acting as a trustee.
And how do you resolve that problem?
Sometimes they can be removed. If they're incompetent and cannot follow the terms of the trust, sometimes there are ways to have the trustee removed.
Or we can, add a co-trustee, the next one up in line, that's others.
No, that's why it's important to look at your documents now and review them. I say at least every 3 years. Because people change, laws change, situations change, people born, people die, people get married, people get divorced. Look at these documents every 3 years and say, does this trustee that I chose, do they meet all those qualifications still? They did when I appointed them, but maybe not so much now. So look at them and make sure that they can do it. That's when you replace them and say, it's time to make a change.
And that's what the question is, what is that process of replacing?
Oh, we just do an amendment to the trust.
No, well,
Who authorizes that?
so you have the
Trust
trust protect, the trust protector provision.
If you're able to change the documents,
No,
you can change it anytime you want to change, as long as you're capable.
no, I'm talking about, you're gone now.
Yeah.
Oh.
And you have a successor trustees, but he runs into a problem. Like can't make a decision as an example.
Most of the documents we do, not all of them, most of the documents we have a provision called a trust protector. Texas authorized a trust protector provision. I call it the policeman for the trust. And what they can do, if something needs to be fixed in that trust and you can't fix it because you're incapacitated or you're dead, then a trust protector can fix the trust. Remove a trustee if they're not doing their job, replace a trustee. Maybe the law changed and we need a clause in that trust that's not there. And you didn't put it there because it didn't apply when you were alive, but we need it in there now. A trust protector can actually change the trust to fix it.
But if you do not have that clause, the trust protector clause, then what do you do?
Well, you should have come in and we fixed it and put one in.
Well, there's usually a clause that says you can remove a trustee through the court process.
Oh, that's the answer to court.
We can go to court and do a lot of this.
But I've seen situations where you've got someone who's a trustee and maybe they're easily influenced by others. And sometimes their spouse starts inserting their views on what things should be done. And you end up having someone who is never supposed to be part of the trust making decisions or influencing the trustee to make decisions that may not necessarily be what mom and dad wanted. So it's really important. If you have someone who is cannot stand on their own and make decisions independently, or at least with good counsel, we ought to review who's serving, because I'm gonna steal the thunder, but as we go through this, being a trustee is not an honor. So if you are, it is a hard job. It can be a hard job. Sometimes it's easy, but it can be hard. And there's a lot of decisions, and you've got to treat family like this is business. You've got responsibilities you have to do. So if you can't do them, then we need to find someone who can.
So when does the successor trustee take over? Well, they take over. If you become incapacitated, obviously you can't be a trustee anymore. So somebody else is going to have to step up and be the trustee. A lot of times it's the spouse. If the spouse can't serve for some reason, then we got to pick up somebody else. Maybe it's one of the kids, maybe it's somebody else you chose. Obviously, when you die, somebody else is going to have to step up. If the trustee resigns, we've had trustees resign. We've had corporate trustees who were named as a corporate trustee, and they said, we don't want to serve in this case. We're not going to serve. Now what do you do? Well, we got to have provision for who takes over if that trustee decides to resign, or sometimes they can be removed. If they're not doing their job, they can be removed. Yes, ma'am.
I'm curious why a corporate trustee would not want the case.
money. If there's not enough
Doesn't pay
money,
enough?
well, if there's not
Okay.
enough money in the trust, they'll say, we're not going to handle a case that has less than $500,000 of investable assets. We're not interested.
Yep.
For the liability, they want to do it.
If some of you have trusts, once you have a corporate trustee, we ought to look at your assets because they have ups their requirements. And I've run across trusts where a corporate trustee is named, but they're not going to serve because there's not enough assets under management for them to want to take on that role. So if you have a corporate trustee, we just need to make sure that you meet the requirements for them to take.
So what do you do when somebody's incapacitated? Well, most of our documents say that when two doctors say you can't take care of your business or financial affairs anymore, by definition, you're incapacitated. Now, I've saw a document today where there was a committee which consisted of several individuals and a couple of doctors, and they got together and they determined if somebody was incapacitated. I never did like that method because if somebody's incapacitated, we probably don't have time to get a couple of doctor schedules together and get all these people together. And it might take a month or so to find out if somebody's legally incapacitated. I want this done quick. So I just, most of our documents are going to say when two doctors say you can't take care of your business and financial affairs anymore, by definition, you're incapacitated. So what happens, we get a new, what's called a certificate of trust. The certificate of trust is the authorization to act in behalf of that trust. You talked about appointing a trustee. Well, that trustee has to have this document called the certification of trust. That's their authorization to act on behalf of that trust. That's the document. Okay. Similar to when you go, anybody been to probate court? Nobody been to probate court? Okay. She goes all the time. Okay. When you go to probate court and you want to be in charge of the estate, the judge appoints the executor as the executor and issues what's called letters testamentary. It's one piece of paper, but they call it letters testamentary. That's the official authority to act on behalf of the estate. The certification of trust is the trust equivalent, so to speak, of the letters testamentary. It's the authority to act on behalf of that trust.
Okay, the question, you say a new certificate. Is there an existing?
Yes.
In your book.
Yeah, your bank says you're the trustee. So when you went to the bank to say, I want to put my bank account in the trust, they said, well, how do we know you have a trust? And what I thought you said, but you showed them a document that said certification of trust that certifies that, yeah, you are the trustee.
So
That's
the
what you showed.
privacy affidavit that we give them, the little packet that you use to give all the banks, there was a certification of trust in there.
Okay, so the new certification is for the
New trustee.
successor.
Yeah. For the new trustee. Okay. So what you ought to do too, you need to find the appropriate documents to go with that. When somebody's incapacitated, there's a HIPAA authorization. You want to make sure you have authority to talk to all the doctors and medical providers. And you also want to find that financial power of attorney and the medical power of attorney and the living will. And these documents do change fairly, well, not too often, but there's been some changes within the last several years. If you haven't updated your powers of attorney or medical powers of attorney, that probably need to be looked at because there's been some changes in those to keep them current. And then the trustee needs to become familiar with the assets.
Can I ask a quick
Yeah, sure.
If you're already named in trust as successor trustee, you have to get a new certificate.
Yeah,
You
yeah.
Transfer of it.
You may be named as trustee, but you're not trustee
Okay.
until you get installed as trustee. And you get installed as trustee by a certification of trust, which you will sign saying, I hereby accept the job as trustee. Then when you did that, then now you're installed. But just having your name in a document, we have that all the time. Somebody come in and say, well, I'm trustee. No, you're not. You may be appointed trustee, but you're not trustee until you're installed.
And I want to bring up something where, I'm seeing phone calls from children and maybe, let's say mom is showing some dementia and some issues with making decisions. And they're saying, well, I need to declare her incapacitated so I can take over. And that might be so. But once you get those letters of incapacity, it's kind of like opening a box. It's very hard once you're declared incapacitated. In order for them to regain capacity, you have to get two doctors to say they've regained the capacity. So sometimes instead of declaring them incapacitated, if they're not, we're not worried about them being taken advantage of. There's enough oversight. They're not spending money in a disadvantaged way. Then maybe we just add a co-trustee to serve with mom instead of declaring her incapacitated. Because once you remove a trust maker as trustee, the trust no longer can use social security number. So now you have to file another tax return. And so it's not complicated, but it changes things. So and sometimes we definitely have to remove a parent as a trustee, but there may be a workaround. So it depends on the circumstances. So if you have a situation in which you think mom or dad are developing signs in which we're questioning their ability to handle things, call us, let's talk about it, because we may not want to automatically declare them incapacitated. Maybe we want to just get enough kids on the accounts for oversight and then just manage assets. But real life example, things going on.
So what do you do if somebody becomes incapacitated? What does the trustee do? Well, first of all, you gotta confirm what's in the trust. A lot of people don't know what's there, and you gotta know what's there, know what I'm gonna be managing. If I'm gonna manage, I think I need to know what I'm managing. You need to make sure the important bills and taxes and expenses that need to be paid are paid. And then we need to remove that current trustee from the bank accounts. If you got somebody who's incompetent or incapacitated, you certainly don't want them in charge of the money. So you got to get them off of those bank accounts and make sure they're removed from those accounts. Then if they need care, you make sure that the disabled trust maker needs care, we'll oversee that care. If there's any business that needs to be taken care of, trustee does that. Surround yourself with advisors. I mean, lawyers, CPAs, financial advisors, their job is to help. And so if you have questions, don't hesitate to contact them to get some help. And by all means, if you're a trustee, successor trustee, keep accurate records. It's very important. In case somebody questions your authority or questions what you did, you want to be able to justify all the actions that you took. Now, when somebody dies, there's also another checklist. We got to get a new certificate of trust. This person's dead now. We got to get a new certification of trust to identify who that successor trustee is. You get the death certificate together and take that certificate to all the banks and financial institutions to get authority. You pay the debts and taxes and expenses. You confirm that all the assets are in the trust. And if they're not in the trust, you find a bank account or a piece of land or some asset that's titled in that person's name, then we may have to go through probate to get the assets put into that trust. It's very important to get a date of death value of all the assets. So this is a problem area for us. We have trustees, successor trustees that we work with, and we tell them that we have to get written proof of the value of the assets on the date of death. And so they'll tell us, well, this property is worth X number of dollars, got a house worth $350,000. They'll tell us, we got about 16,000 in the bank, whatever they've got, they'll tell us these numbers, and they don't have justification for any of it. Okay. It's important because when somebody dies, the recipient, the beneficiary, gets what's called a step up basis. Does everybody know what that means? Anybody not know what that means? It's okay to say, okay. You buy some stock for $10,000. You hold it for a while, now it's worth $100,000. Now you sell it. Okay, you got a $90,000 gain that you got to pay capital gains tax on. Okay, but that $10,000 stock that you bought a long time ago, you kept it. It's now worth $100,000, but you died. And as a result of your death, that stock passes to someone else. They get a step up in basis. So that $10,000 basis that you have, now their basis is $100,000. Now if they sell it, there's no capital gains. Yeah, that's why we need the date, and we need the date of the death value as of that date, because that's the date the basis steps up to. Yes, ma'am.
So for this date of death value, in regards to houses, we have virtual theaters. So let's say we go past both of our sons, what the houses get. You just use market value?
You get comparable, get
Okay,
comparable. Yeah.
Zillow, whatever,
Yeah.
you just
Yeah.
get it
Yeah.
for that date.
Yeah.
Right.
Yeah.
To what level?
What do you mean with that?
Well, is there a cap? Well, if you get a house that.
You get a full,
It's fair market value. So you take the high, you take the low, you take the median is what the value of the house is.
I think he's meaning on this, avoiding capital gains tax on a step-up basis. Is there a limit to
on
the
death,
step-up
no,
basis?
on death, they get a full step up on that.
So basically, it avoids all capital gains tax.
Yeah. Exactly.
Okay.
Okay, we're okay now?
Well, some things I want to point
Richard?
out here.
There's been some talk in Congress about elimination
Oh, yeah.
of step up.
Always is.
Okay, nothing's happened yet.
Not yet.
Okay,
They can't agree on what kind of sandwiches to get. So they talk about that all the time. So I'm not worried about it.
If you are a co-trustee serving with mom and dad, and mom and dad pass away, just because you were named as a co-trustee while they were alive, you have to be, as we talked about earlier, installed as the death trustee. So you can't just go to the bank. You don't have legal authority to continue on once mom and dad are gone to your co-trustee. So that's something that I get is lost. If they say, well, I'm trustee, and sometimes who they've appointed, who mom and dad have appointed to help when you're in life, it's not be the backup trustees. And so, yeah,
Is that true of any
any
co-trustee?
co-trustee.
If I die, she has to do something?
She needs to have a new certification of trust, because otherwise they're gonna look to her, to look to her for you. And she'll say, where's your husband?
But she doesn't, they should not have to look to me if she is also a trustee. Why do they have to look to me?
Is she a trust maker? It's up
Well,
again.
so is she. She's a trust maker. It's
So you're talking about trust make, so trust makers are different. Trust makers. I thought you were talking about
It's
adults.
gonna depend on how the trust is written. It's gonna depend on how the trust is written. So,
And so we have some trusts where wife has incapacity, as dementia, and so we have specific provisions that she cannot change the trust. And so it just really depends on her own. So it depends on her.
My question has to do with, if you have co-trustees, even three, if we have as a child, in addition to mom and dad. But if you just had mom and dad, he said, well, mom and dad died, even though he was a co-trustee, he's got to be now a successor. Yeah. But if co-trustees, you only have mom and dad and one dies, then they also have to be a successor.
not necessarily, they can continue. Depends on what,
So why does the third one die? You need a co-trustee, I mean, a successor. But if the second one dies, you don't.
it's gonna depend on how the trust is written. So it could say, one of us dies, then the surviving trust maker serves as the sole trustee. Or it could say the surviving trust maker and Johnny serves as co-trustees. Then we gotta bring Johnny in. Okay, so it's just gonna depend on how the trust is.
But you always want your documentation to reflect the current status of affairs. That's why it's called a living trust, because things change. So when you're representing yourself to a financial institution, you just want to be clear on who the players are. And so that's why it's just common practice
So go back.
to redo the documents to express what's going on in the family.
The other thing you have to do is you have to notify the beneficiaries. Some people don't want to notify the beneficiaries. They say, well, I don't need to tell them anything. I'm just gonna hold this thing until I get it all done, and then maybe I'll tell them later. No, That happens. It happens. You gotta tell the beneficiaries. And then we distribute the assets according to the trust, not the way we want to do it, but according to the terms of the trust. But Dad wanted to give him $100,000. He always said that. If the trust didn't say it, then you can't do it. Okay?
And what I see is that really, if you go back to that slide, I'm sorry. But to get the new certificate of trust, if something happens and someone passes away, we do not need to be the first call by any means. But before the trustee does anything, they really need to talk to us or someone like us. Because, and we're going to talk about a lot of examples on the don'ts of a trustee, but we're having so many families come to us, and maybe it's only been 2 or 3 weeks since mom or dad has passed away, but child has already distributed assets, done things in the short amount of time before they come to see us, and they're not right. They're not correct. So before you start doing anything regarding what you trust, get counsel, because you could be liable for doing something wrong. An attorney does, so we be clear.
If we did your trust, which most of them we did, take a look behind a tab called the information page. There's a document in there. It says, a lot of people miss this. This is just 2 pages. Actions to take upon disability or death. And there's like 18 things to do when somebody becomes incapacitated or die. These are the steps. You do this, you do this. There's steps laid out in your book. Okay.
It's under the overview section.
And then number 7 is call us. Okay, so that's a bunch of stuff you do before you even call us. But it's a helpful guide to let you know, because a lot of people don't know, what do you do when somebody dies or becomes incapacitated? Well, we've laid it out for you.
And
So
where is it in the trust?
I think it's under the information section.
It's under,
Information
so it's in the overview section behind the trust summary. There's either a blue sheet or a green sheet divider, and then it's checklist for incapacitated.
Okay.
Ready?
Okay, so what are the duties, what are the practical duties of a trustee? What do we want the trustee to do? First thing, this is what, I don't say nobody does it, but I'd say a lot of people don't do this. Read the trust, read the thing, it's thick. Our documents are written in English where you can understand them, so they're not in legalese where it takes 3 or 4 lawyers to figure out what it says. They're understandable. But read it and understand it. If you don't understand it, call us and we'll go make sure you do understand it. Okay. Don't mix your own assets with the trust assets. Don't pay your bills out of mom and dad's bills or whoever you're trustee for.
Well, and don't pay the trust bills out of your own money, which I had that happen today. So if it's your bank account, don't be paying trust bills with your money.
Or don't pay your own bills with the trust money. We've seen it. We've seen it. You got to treat all the beneficiaries the same. You can't pick your favorites. You got to treat them all the same, even though you may not like one of them or 2 of them. You may not like them, but you got to treat them the same. And then you got to invest the trust assets in a prudent manner. It is prudent. You can't speculate or gamble. Use unsound business judgment. You got to invest in things that are prudent. And then please keep accurate records, because believe it or not, you may have a perfect family, you may have a perfect situation, but you gotta know that there's gonna be sometime down the road that's gonna tell you there's gonna be somebody who's gonna question what you did. Question what you spent money on, and then we got problems.
And also, the good news is that in your trust, it says that you are entitled to reasonable compensation for serving as trustee. So no one is expecting you to do this for free. But it's important to keep accurate records. So when you do claim a compensation for your time, that you can justify it with all the work that you have.
And I will add on compensation really quick. If that's one of the areas that I see people get the most upset about. Why is sister getting paid to help be a trustee? Even though it's taken sister over 200 hours to do the job, right? So if you are doing compensation, keep track of your time and talk to us before you just put a number down. We will help you calculate compensation based on what we think the court will approve. So if your compensation's out there on the table, but I wouldn't do it without us. Let us in on that decision.
Is there like an average number per hour or something?
Yeah, it's too complicated for me to tell you. It's a
Okay.
spreadsheet. There's a lot of things going on, but yes, there are different things that we can go to.
And it has to pass the smell test.
That too.
Yeah.
$500 to clean out somebody's garage is a little bit steep.
Yeah.
See, Mike, well, you said-
It's steep. I can hire somebody, I can hire a kid to clean it out.
Who can be the arbiter of what is improvements in investment or not? Because it's a judgment call.
It is a judgment.
I mean, like cryptocurrency is becoming more and
You
more,
know,
I think, but some people may not consider that. prudent. So
I
who
was
gets to
just
choose?
trying to say, you know, it's really, it's when it busts, it's when you're gonna have the problem.
Sure.
So if it doesn't ever bust, maybe it's not, important, but if it does, then
Yeah,
it's gonna be bad.
I'll say there's case law. There's a lot of case law on that helps us determine what's prudent and what's not prudent. In my opinion right now, just my 2 cents, if I was a trustee, I would not be investing in cryptocurrency yet. But it's a good example because it's one of those things that could become prudent and in certain situations is prudent. It's a good gray area. So if you are thinking about investing in something that is like that, talk to us first. If it's something that the beneficiaries agree on, you know, we can talk about that. Or we can wait until it gets into their trust and then they can invest it themselves, right? So, but yes, there's a lot of case law out there, and that's a really good question because it's a gray area and a hard topic to nail down.
You have a question? Yes, sir.
I'm curious about the assets which is distributing the beneficiaries. What kind of time frame are we talking?
Well, the job of the trustee is to gather all the assets together, pay off all the legitimate debts, and then distribute what's supposed to go to where it's supposed to go. Okay. Unfortunately for the trustee is personally liable for paying the debts and expenses and taxes of the trust from the trust funds. If they don't do that, then if they distribute all the money up front, you get rid of it, and then we find out it's all these taxes and expenses they gotta be paid, but the trustee has to pay them personally. Okay, so we withhold a certain amount of money to do that. Okay, and so how long is it gonna take? It depends on how long is the administration gonna take? Sometimes administration can take a month, 2 months. Sometimes it can take a couple of years. You know, don't know. We gotta look at probably if we got a taxable estate, but there's income tax due, probably gonna wait until at least April 15th of the next year, at least, to determine what the taxes are. Then the IRS has 18 months to challenge that after that. So if we know they're not gonna challenge, no problem, but if we think there might be a problem, then we're gonna withhold those funds. That's where they gotta be invested prudently.
But that's also maybe more of a situation in which maybe mom and dad are incapacitated. So you could be investing for long periods of time. But when you're upon death, the idea is we're trying to get everything distributed in the next year. Latest.
But shocking.
Question on tax return. Let's say I die in mid-year. So the successor trustee will file a standard tax return for me from the beginning of that year to when I die.
Yes.
So it'll be filed in April 15th of the following year.
Yes.
When does the process for a trust return start? At death?
Yeah.
And it's a separate process.
Right, it's a separate return.
Is it on a calendar basis or what?
Well, it'd be the same thing, being due April 15th, but it's a 1041 instead of a 1040.
So it'd be a partial return the first year
For
until,
partial year.
and at the liquidation of the trust, assuming it's liquidated, then,
The final return.
and then the final return, trust return.
Right.
Okay.
And that's why some people say, well, I just want to keep this trust open and invest, and I don't want to distribute to the beneficiaries. I just want to keep it open. We have someone now who wants to keep the trust open indefinitely. But you've got to file that administrative tax return every year. And so these trusts aren't meant to stay open indefinitely. The idea is,
Except when he goes to the beneficiary.
but it's not meant to be a holding tank and not distribute. It's get it to the kids or whoever your beneficiaries are, and then be done. And then the beneficiaries have their own, have the trust that's created, but the administration report from the trustee is over.
Knowing that there's this time lag, can you partially distribute some
Yes.
assets to the?
Make partial distribution.
As long as you're covering the debts, taxes, expenses, but yes, a lot of times we're not trying to keep money from families, we want to get it in your hands just as soon as possible, but you also have to protect the trustee, because if they give too much away and now they got to pay bills, they're personally responsible. So we want to get it to them, but we got to be smart about it.
Is there a tax problem with, giving the money away?
No, it's a
Before you die?
before you die,
Yeah,
it's a gift tax.
right?
It's a gift tax.
Yeah.
Then you can make a distribution if they're a beneficiary. If they're not a beneficiary, you just give property away. It's
Any taxes or anything?
Just over 19,000, there are.
What?
Well, there's a return if you give more than $19,000 away this year.
How much?
Or there's a return, an informational return that you have to file. You're not paying any taxes because you can give up to $15 million away now of your lifetime. But if you give more than 19,000 away, the IRS wants to know about it.
In a year. 38,000 from married couple to one individual.
Then I think it's scheduled to go up.
I'm sure.
It'll go probably 20,000. All right. So some trustees do this. What do you do? Well, you gotta establish your authority as trustee. You gotta have to stand up and say, look, I'm in charge, and let everybody know that you're in charge, and you do have responsibility, and some duties to follow, and that some people, your siblings may not like the fact that you're in charge, but you have to say, look, I've got the responsibility, I'm gonna be in charge, and we're gonna do it according to the terms of the trust. Got to determine the nature and the value of the assets and take control. You gotta know what you're in charge of. Set up proper accounting procedures. Establish communication with the creditors and the beneficiaries. Let them know what's going on. If you're in charge of a trust as a trustee and the beneficiaries or the creditors never hear from you, you know what that means? So it means you're not doing anything, right? Well, you may be doing a lot. You may be working real hard as a trustee, but if they don't know that, then they're surmising that you're not doing anything. So it's important to keep established communications with the right people. If there's any problems or disputes, you want to get those resolved as quickly as possible. Letting them linger on very well could lead to litigation. And then you definitely want to carefully follow the trust's directives. Unless the trust says you can do something, you can't do it. And so you want to make sure you follow the terms.
Can I step back 1 second? Did you say that they could make an early distribution, but while they're still living, to the beneficiary trusts?
No.
Okay.
The beneficiary trusts don't come into play until they die.
Okay,
You can give money away.
correct, but I thought you
No,
said the
I'm sorry.
beneficiary trust, so then I was like, wait a
Well,
second.
you can do a beneficiary trust and an irrevocable trust while you're alive. You can set up your irrevocable trust and you can give as much money you want to that. If it's within the tax limits. But
But it still has to be within the gift tax,
well, no, it has to be within the 15 million.
within the 15 million.
Yeah.
So does that circumvent the annual gift tax?
You get the 15 million plus 20,000, 15,000, 19,000.
Okay, so you're still set at the annual 19,000.
Yeah. You still get that regardless.
Okay.
Yeah. All right. Well, here's some things not to do. Don't sell or distribute assets until you see an attorney.
That seems to me self-explanatory, but we're seeing it every day.
Last week, brother and sister come in and they say, well, is it okay? And she wasn't even named as a trustee. And she says, is it okay that I gave away $160,000 away to 3 beneficiaries? And that okay? No, it's not okay. You don't have any authority whatsoever to give any money away, especially if you're not a trustee. but she did. but-
And she gave it outright. She didn't even give it to him in trust, which was what the trust said.
So it's a problem. Okay? And the problem comes, and Lindsay, you may speak up on this, but when most of the time we leave property to our beneficiaries in trust for asset protection purposes. Creditors can't sue them and get their inheritance. Ex-spouses can't get it. And if you file bankruptcy court can't get it. But if we give it outright to them, like that $160,000 goes outright, it's not in trust, it's not protected. What happens if somebody sues them and they lose that inheritance? Do you think that they might have a claim against the trustee? Usually it's because their next door neighbor knows a lawyer. And that lawyer says, well, they shouldn't have given it outright, they should have left it in trust. You ought to sue the trustee. Does that ever happen?
Yes, I think the things that I see happen when people are mad at whoever you appointed successor trustee, I think I can summarize how they get sued. Their fellow siblings or fellow beneficiaries either don't think they're doing it fast enough or don't feel like they're doing it right. And think and feel are really important words because it doesn't have to be the truth. It just has to be what they assume. So if you are doing something that you shouldn't be, like distributing money outside of trust, and they sue you, you might lose and get removed. But you don't even have to be doing something wrong in order to get sued. I think that's something I really kind of wanted to make clear. They just have to feel like you're doing something wrong in order for you to be sued. And then you're spending tens of hundreds of dollars defending yourself in a lawsuit as trustee and using everybody's inheritance. And we'll talk a little bit more along the lines as we go. But your communication and following all the rules that Richard and Marcy are talking about today, if you're appointed successor trustee in your parents' documents, or if your kids are appointed, are so important, because the whole goal of this is to set you up that if anybody feels like you've done something wrong, they at least won't be right. And so to start that off, just talk to us. If somebody passes away, we should be on your radar.
Does the trust include language that requires a distribution be in trust?
Not always, but most of the time it does. I mean, most of our trusts do. I mean, we've got trusts where we give outright distributions, depending on the situation. Maybe it's a gift of cash, or maybe it's something that an item that we give away. If it's a large amount, usually for the asset protection, we leave it in trust. Normally, if the child is capable, we'll let them be in charge of their own share. They get to be in charge. They get to be their own trustee, so they can take it out. But they're in charge, but it's still in trust. It's protected.
That question, did you just say that if they do not have a beneficiary trust, that the successor trustee can be sued for distribution? Is that what you just said?
Successor trustee can be sued anyway.
No, what he said is if the trust calls for a beneficiary trust to be set up and they don't follow the terms, then if something happens to that inheritance, they can say, hey, you didn't follow the terms. I'm going to sue you.
I understand.
So even if the kids don't want it, or maybe one kid doesn't want the trust, what we advise the trustee is that you got to follow the terms of the trust. Give it to the kids. They put it in trust, then they're in charge of it. If they don't want the trust, fine. They can take the money out and put it in their own account. And if they ever get sued, they can't come back to the trustee because the trustee followed the terms of the trust. So at least that way, the trustee has done their due diligence.
All the time, we have 3 or 4 children as beneficiaries, and they say, we don't want it in trust. We don't want to fool with the trust. Just give us the money. Okay. And I tell the trustee that if you do that, if you just give them the money and they lose it later on, then you're liable. So when we handle administrations, the person that we represent in an administration is the trustee. So our job is to make sure that the trustee doesn't get sued, is not liable. And so they don't become liable if they just follow the terms of the trust. If they do what the trust says, then nobody can complain. It's just that it may be inconvenient on that beneficiary to get in trust, they may think. And if they don't like it in trust, they can take it out of the trust and do whatever they want to. we give it to them in their little bucket, they dump that bucket on the table and not have it. It'd be very foolish to do that, but it's up to them to do it.
But if your trust does not call for a beneficiary trust, there's nothing at all wrong with just giving it to them.
That's right.
Absolutely.
That's right. You follow the terms of the trust.
Question does, let's say there's just one trust and I die. Does that automatically create 3 trusts for my 3 children?
No, sir. So logistically, what happens? The trust is, the beneficiary trusts are provided for in your trust. Well, we have to physically set those trusts up. And just to tell you what we do is we take the sections out of your trust that deal with that beneficiary and we create a small packet. I've got to get a tax ID number for that trust. I've got to do a new certification of trust that says that your child is the trustee so that he can take it to the bank. So there's some paperwork that has to be done. Plus, we do an inventory of all the assets. So we know what 1/3 is that goes to that child. So there is some paperwork that has to be done. And there's
Physically, what happens is that you have a trust, you die. That those funds go into what's called a temporary trust, an administrative trust that holds the assets. And then we can make a partial distribution from that administrative trust into separate trusts for the beneficiaries. Okay, we can make a partial distribution, but the temporary administrative trust pays the bills and taxes and expenses. And then once we've done that, then the rest of it is in the administrative trust, we divide it to the trust of children.
But there is little paperwork that has to be done, and I think that's been a misconception, is they think, oh, well, the trusts are created, I don't have to do anything. And there is paperwork to physically set up those trusts and determine what the assets are. The difference is you're not doing it through the court process. It's private, it's on your timetable. There still may be a few things that need to be done, but it's done in private.
And what is the involvement?
You still would have to do, then 3 children, 3 trust returns, right?
What's
The
that?
children,
The children will
the
do
children
that.
have their own.
I mean, they would,
Yeah.
yeah, that could not be.
Yeah.
Yeah.
Yep.
As long as the trust, their trusts are still.
Exactly.
Are the beneficiaries solely in control of the beneficiary trust?
It depends. It depends. Usually, but not always. You have a minor child, no. You have a child who's not capable of managing money, no. You have somebody else in charge of it.
Okay, assuming that's not the case,
Usually they're in charge of their own share.
that, okay, they are completely, they are the trustees.
Yeah.
No.
Independent.
Usually that's true. Not always.
Just to have an understanding, the other beneficiaries that all these trusts, what is their involvement in this paperwork? Do they have to come in and help complete the paperwork?
No.
Is it their tax ID number or is it issued with separate tax ID?
So what happens, the trustee, whoever's named as the death trustee, they're my point of contact. They come in and say, try these happen, mom and dad are gone. And so I'm gonna work, say in your case, I'll work with you. We get all the data death values. We create these books. We decide, okay, it gets however many percentages there are, however many books we create. And then the only thing they have to sign is a new certificate of trust. So either we can distribute those to you to distribute out to your brothers and sisters and they get it signed. You then write a check to their trust for a partial distribution. They take that check with their book to the bank and open the account in the trust. They are not involved, really. I really,
Other than they need to go open a bank account.
right.
Our
But I really-
client is the trustee, not the beneficiary.
I do not. Usually, it's just better to have one point of contact, you know, and everything come through that trustee, because I've had it to where I've had 5 and 6 siblings calling me, and it just gets convoluted. So we just try to streamline it and say, hey, represent the trustee, we're gonna get you your stuff and answer all your questions, but let's have a point of contact to get this done.
And by them signing that certificate of trust, that's them accepting their beneficiary trust and naming them as the trustee of their beneficiaries. Okay.
But once the beneficiary trusts are created, then you are they are clients of yours, is that right?
No,
Not necessarily, no.
I just represent the trustee who set up the trust. Now, another thing, sorry, just a point real quick, is that they have a beneficiary trust. That's their inheritance. This trust that we create is not a living trust. They still need to do estate planning for their own assets. I've had kids think that they're getting the same plan that their parents had. That's not true. They're getting an inheritance, but they've got their own assets. So they need to either do a will or a trust for their own assets outside of their inheritance. And I've had to explain that.
So that means the only assets in beneficiary trust are the ones that come from,
Mom and dad.
That's right.
that's the only one.
That's the
assets
one.
in-
Yeah, if they mix their own assets with it, it kills the asset protection. So they don't, well, you don't want to have your kids mix their own assets with that beneficiary trust. Okay, so some other things not that they don't sell or distribute assets until you see an attorney. These people last week said it's okay. We gave the car to my nephew. Is that okay? No, you can't do that, you know, but they did. So what do you do? Don't engage in self-dealing. Don't allow a conflict of interest. Don't keep full records and don't fail to communicate with the beneficiaries. These are all just common sense things. Don't allow disagreements to be resolved. Work it out, talk to them, talk it out, find out what your beef, what can we do to fix it? You know, let's don't let things linger because animosity builds up if they think you're not doing what you're supposed to be doing, and it's a problem.
Question. I know you have to the value of assets, but tangible assets, like the car you just gave an example of. If all of the beneficiaries are in agreement to deal with a car in a certain way, giving it to one as long as you know the value of it, that is then calculated into that one beneficiary's distribution.
Can be, yeah.
Right?
Could be. I mean, a lot of times we do family settlement agreements with the distribution. So if all the kids say, you know what, we all agree that we're gonna give this to this person. Well, then we all agree in an agreement, so no one, it's documented.
Just when you're dealing with antiques and tangible goods, and how does that happen? How does that play out if you don't just liquidate it?
You can reach an agreement on those kind of things. Personal assets, you typically reach an agreement about who's gonna get the stuff.
Unless the trust specifies
Yeah,
things to go to certain.
yeah, the trust gets specified specific
I
things.
mean, I've seen lots of
Usually they just work it out.
lotteries. Things get creative, but usually we say, okay, you tell us what you want. Let's see if anyone else wants it. And if there is, we'll come to an agreement or figure out the price. Maybe you buy something, so you know what, I'll trade you this for that. And so,
Who gets that?
But are all of those types
Yeah,
of
we
things
can tell.
in the calculation? I can understand little things not, but things of greater value, is that all in the calculation of the overall distributions?
So whenever we do an inventory in the probate process, we will give an estimate of whatever the value of household items are, right? Furniture, things like that. But if there is anything that has value, like an antique, a diamond ring, whether it be monetary or sentimental, then there are pages in the back of your book where parents can write out giving those specific things to kids. From a litigator's perspective, if there's something that has sentimental value that doesn't have that financial value, give it to your children during life or give it to one specifically in the book. Because I have spent tens of thousands of dollars in attorney's fees fighting over jewelry in an estate before that did not appraise for more than 20 grand total. So that may not be the direct answer to your question, but whether it's monetary or not, if y'all are going to agree that things are going to be distributed, you need to do a family settlement agreement, even if it's a car, because that protects you. And if you're talking about antiques, that word just red flags for me. Give it to someone who may want the antique. If we're going to fight over it, give it to them while they're alive, if you can, or write it in the back of your book, those pages that say, my diamond ring goes to this child, so that we're not fighting over it after that.
That's to sell the car before you die.
If you can.
If you can, yeah.
You're not supposed to be driving that long.
Good advice. All right, what else do you not do? Don't act independently of the trust directors. Don't say, I know mom, dad really wants me to do it this way, I'm gonna do it that way. No, we gotta do it according to terms of trust. Don't take an unreasonable compensation. You know, what's a reasonable compensation? Our trust have a provision for a reasonable compensation. What is that?
But you know, people say, what is that? You know, what can you pay someone to step in your shoes and do this job? I mean, $100 an hour, easy. $150 an hour, maybe more than that. But it's gonna pass the smell test. But
We use the term reasonable because, you may die and, it takes somebody a month to wrap this thing up. And, didn't spend a lot of time in it, didn't cost much. And so the fee might not be very much. But on the other hand, you may have been killed in a car wreck that was somebody else's fault. And you have a civil lawsuit against the people that killed you. Now this lawsuit's going on for 3 or 4 years. And the trustee has to be involved in that process. That could be an astronomical expense for the trustee. So that's why we put the term reasonable, man. We don't know what the situation's gonna be. So whatever's reasonable, that's what we use. Don't delay the administration. Don't just drag your feet. We've got cases where people have dragged their feet. You know, 2 or 3 years goes by and still haven't got it done just because they just won't get it done. I mean, the idea of doing a trust is we don't have to wait months and months and months for probate. But sometimes we wait months and months and months through trust administration because people drag their feet. So that's probably not a good idea to do that. Don't miss any tax deadlines. There are some tax deadlines that we have to deal with, even though it's a trust. And please don't commingle funds with your personal money. You gotta keep things separate. Because
I had someone who called me a couple weeks ago, and it had been 3 years since dad had died. And they distributed everything on their own, but they'd run into a snag. It was only then that we learned that she gave the money to the wrong beneficiary. She thought that if her brother was dead, that it all stayed with her. And it didn't. It went to his kids. And she misread the trust. So, you know, don't delay administration. Like I said, we don't have to be the first phone call. I don't want to be the first phone call. But just check with their attorney. There may be nothing, don't worry. There may be nothing that needs to be done. If it's all going out right, there may not be much of anything we need to do. But better for your own sake, because you are personally liable, for you just to get an attorney's okay, this is what you need to do, than to think you're doing it right, only to find out that you're not, and then, you know, wolf for it.
Okay. So can you be sued as a trustee? What do you think? What do you think?
Yes. We can all be sued.
So a surviving spouse is a trustee of the trust. So some trust, maybe some of you have a provision in your trust, maybe you do, maybe you don't. It says there's a remarriage protection clause. It says if you get remarried, then you gotta do certain things. That's what happens if you don't do those things.
Are the trustees, bill or whatever, they just, do their fees get paid out of the trust? Just
Yes.
for being?
Yes, ma'am.
Okay.
Yes.
So
If it-
anything that's probably.
Yes, if a trustee gets sued, they pay for their attorney's fees out of the trust. Whenever we're negotiating in a settlement, the attorney's fees are always going to come up. Beneficiaries are always going to want their attorney's fees paid too. That's always a part of the negotiation when we do settlement. And a lot of these cases will settle. Frankly, at the end of the day, it eats up everybody's inheritance equally, especially if the trustee is also a beneficiary.
And the cost of creating the trustee trust comes out of the trust also.
Yes, the beneficiary trust, the cost of creating the beneficiary trust comes out of the trust. Yes. Any expenses or relation or taxes, debts are paid from the front. So yes, if you have remarriage protection, I think Richard brings this up because I have a case right now where husband was told that if he remarried, the trust split, he didn't have access to a portion of the trust if he remarried. and he remarried and continued to get access to the portion of his trust. So we are in a huge lawsuit right now, fighting over whether this remarriage protection is defensible, whether he should have access to the trust or whether he should have access to a portion of the trust. It's very expensive to fight over this. At the end of the day, we'll probably end up settling because very few things go fully to trial just because the cost usually isn't there. I mean, it can be $100,000 before we even get to trial. So when your spouse passes away, you think, I'm co-trustee and I'm also the trust maker. So I can keep going under the trust, right? It's really important to just come in and talk with Richard and Marcy or even myself. Let us look at your trust and make sure that you can keep doing things even if your spouse has passed away. That's another really good idea. Like Marcy talks about, to go ahead and get that new certification of trust after your spouse passes away so that everything is updated. If that's something that Richard and Marcy think that you should do. So yes, even if you are a surviving spouse, you can still be sued if you're not following the terms of the trust.
And we're not trying to scare you at all. I mean, we're honored that y'all, are wanting to learn about this. And we're not trying to scare you, but I just want your eyes open that it is a responsibility. It is a job.
Oh wait, sorry, wrong one.
So do you have to serve? If your name is a trustee, do you have to serve? No, you don't have to serve. You say no thanks. And we've had people say no thanks, I don't want to serve. And typically what happens is you go to the next one in line. Okay? So that's why it's important to look at your documents to make sure that the backup is okay with you and that they're still capable of serving. Like I said, people get born, people die. We've had several situations where the backup trustee is now gone. We don't have a backup trustee. Now what do? We're going to have to go through some procedures to get one named, and that can be challenging. So you take a look at these documents regularly, see if the backup is okay, because something can happen and then, you think that the trustee's going to be able to serve all the time, and things can happen and maybe they're not able to serve.
This week, so our daughter is, she's going through chemo and she just can't take on responsibility. So she's resigning to go to the next one in line. It just makes me bad timing. They're not gone, it's just bad timing. So she's resigning. And that's the right thing to do.
Yeah, that's good. Yeah. All right, so you have to do it by yourself, though. You can, like I said, most of our trusts have a provision that says that you can appoint a co-trustee. You need some help, you can appoint a co-trustee to help. That's not a problem. Hire an attorney, hire a CPA, hire a financial advisor. But ultimately it's the trustee who's responsible. So it's their responsibility, but you can get help. So you don't have to do it by yourself. So,
And the cost of those comes out of the trust.
typically, yeah, the trust, our trust has a provision in it that says that, a trustee can hire professionals, lawyers, CPAs, financial planners, investment advisors, whoever to help, manage the trust, and it comes out of the trust funds. Yeah,
So the co-trustee can get paid too.
yeah, sure. So common mistakes is that they don't know what the assets are and they begin guessing. Well, guessing is going to be a problem. They believe they have authority without consulting with an attorney and getting legal advice. Like I said, that couple last week, she thought she was named as trustee. She said, well, they told me I was going to be trustee. We looked at the document. No, you're not trustee. You're not named anywhere in this document as trustee. So it's a problem. And then giving in to outside pressure from beneficiaries not to follow the terms of the trust. That's a big one because this peer pressure saying, oh, those lawyers, they just want to charge a fee. You don't need to do all this stuff. We had a financial planner tell our client that you don't need to deal with that. That's not important. You don't have to do that. Well, it kind of is, And so, matter of fact, it's legal. You have to do it because you have to follow the terms of the trust. So, you got to be careful who you're talking to. Yeah.
So in terms of what you're saying, good communication with the beneficiaries, if you become a successor trustee, you get installed, okay? Then you give a copy of the trust to the beneficiary.
Beneficiaries are entitled to a copy of the
Okay.
trust.
So that way they don't question what you're doing.
They're entitled to a copy of the trust.
You're also entitled to an accounting. If they ever want an accounting, So I would say just be open and honest.
We've had trustees that don't want to give a copy to the beneficiary. I don't want them to see it. Do I have to show Johnny this trust? Well, yeah, he's a beneficiary. You gotta show him, you know? All right, so the best practices is communicate early and often. If you don't talk to them, like I said, they surmise you're not doing. If they haven't heard from him, if they have not heard from the trustee, it means the trustee's not doing anything. That's just the rule, right? So communicate often and early. Document everything. If there's agreement or anything that you're doing, make sure you document everything. Ask for help when you need it, act promptly.
I'll also add to communication. What I've been seeing is sometimes when you're appointed trustee, you'll chat GPT and you'll get answers before talking to an attorney. And then you'll tell your siblings who are beneficiaries, oh, this is what we're going to do. Then your siblings go to an attorney and they're like, oh no, they're completely wrong. And then trust is broken and it is really hard to put it back together. So be careful nowadays. I mean, we have access to Rocket Lawyer, Chat GPT, all of this stuff. Give us a call, because as soon as you give your fellow siblings or the beneficiaries any information that doesn't pass that smell test that Marcy's talking about, or they get conflicting information, then it's really hard to put things back together communication wise.
What happens if you breach your duty? Well, you can be removed, you can be sued. Sometimes there's criminal penalties involved if you violate your fiduciary duty. So there's some serious consequences for not following the terms of the trust.
We don't want any of our clients' names to become famous. Just that,
In the case that you aren't doing your duty and you get sued, then are your expenses out of the trust?
Maybe not. If you're violating your duties,
The
maybe
court
not.
would decide then whether,
If you breach your fiduciary duty, the trust may not be liable for your expenses. Maybe on your own.
Yeah, usually what happens is whenever we get to the end in settlement, then whatever we paid in your expenses to the trustees, so they're a beneficiary too, we take that out of whatever they end up getting at the end. It goes back in the pot for all the other beneficiaries. I've done that a handful of times.
So, as we said before, you know, the trustee, people argue, we have this all the time, we set up trust. Kids argue about who should be the trustee. I want to be the trustee. I'm mad because I should be the trustee. And it's not an honor, it's a responsibility. And once they go through the process, they learn real quick that, boy, I'm glad I'm not doing this. And my sister's doing it, or my brother's doing it. But trust administration can be complex, but it's manageable. Sometimes it's real simple, sometimes it's not so simple, but it's all manageable if you get the right team together.
and you're not doing any of this alone. So tell your trustees, in reality, you know, if you use us, we're going to be doing a lot of the work for you, and we're going to be there to guide you. So even if you're worried about, well, I don't know if my child can, I may have some questions and they don't know what to do. Well, we do this all the time. So I'm going to be their sounding board, and we're going to guide them to do what's right. So they aren't doing it alone if they work with us. We're going to help. Yes, sir.
What about assets outside of the trust? For instance, IRAs. What documents do the children have and need to present to Schwab to establish that they have the right to follow?
Usually it's just a death.
I'm sorry,
Usually it's just a death certificate.
that's it?
And then they'll ask for the IDs of the, you know, driver's license of the
Right,
beneficiaries, and then they write checks.
that's it.
Sometimes the beneficiaries of trust, sometimes the beneficiaries of trust.
So it's usually really simple.
No, I'm talking about assets outside of the trust.
When you you could have the beneficiary of the trust, most of the time it's not, they can't be.
Now, what can happen is there's an asset outside the trust that you thought had a beneficiary and it didn't, and then we have to go through probate. So if you have assets out of the trust, even if it's an IRA, just make sure you've got beneficiaries. If you recently widowed or divorced, make sure those beneficiaries have been updated, so they're going to the right people. So what I don't want, for anything that's out of the trust, for us to have to go through probate. We have talked enough.
So IRAs or tax deferred accounts, you can make your trust the beneficiary.
You can, there's some tax implications of doing that, but a lot of times we do that. I mean, if you've got a minor child, you don't want an IRA going to a minor, because then you gotta get a guardian. So that's an example where we make the trust, the beneficiary till they're at least 18, and then we decide.
There's pros and cons to doing that. Some people want to make sure that their son-in-law never gets the IRA money if their daughter dies. And so you can put it in trust and make sure that doesn't happen. Some people don't care. And so it just depends on the situation, whether or not it's advisable to do that.
Like maybe savings accounts outside of the trust, you can put the beneficiary as a trust.
You can make the beneficiary trust or someone else, but yeah.
I get it. Excuse me. What if your trust has what appears to be an independent trustees for the beneficiary trust as a trust protection? What do you say?
So you have someone else named as trustee instead of the kids. And that's the best asset protection, because the kids don't ever have access. They gotta go through someone else in order to get it. But it can be, I mean, that's a personal choice. That's the way you read it.
That's in my trust.
Well, you've got, but most of you, for the beneficiary trust, it's a little complicated. That's where it gets a little bit complicated. And we're saying that if a beneficiary is trustee of their own trust, they're classified as an interested trustee under the Internal Revenue Code. Okay, and in the document, if you read the document under your beneficiary section, it says an interested trustee can distribute the assets to a beneficiary for their health, education, maintenance, or support. That means lifestyle, for their lifestyle, their needs. Yeah, for only that. But if the child wants the money, they don't need it, they just want it, they can appoint an independent trustee as defined under the Internal Revenue Code. That person can give the money out to the beneficiary for any reason.
Let's say they can appoint who's
The child. The child.
well, why would he need an independent?
Because they want the money.
Because the child had a car.
Well,
It was their fault.
but
And
it's-
Thomas J. Henry has come and they've sued them. Okay, and they say, we want you hurt my client, I want you to pay these damages, and your son says, I don't have any money to pay those damages. Well, wait, your dad just left you a whole bunch of money, plus you got that money, don't you? And your son's gonna say, well, I can't get that money except for my health, education, maintenance, and support. I can't get it for just any reason. Okay, so it's asset protected. All right. So your son later on decides he wants to take a trip around the world. He's got a chance to take a cruise, 3 or 4 months around the world on a cruise. Doesn't need to go. It's not within his lifestyle. He just wants to go. So what he does is he can't get the money himself for that, right? Because it's not within his lifestyle. So he appoints an independent trustee. His next door neighbor, Tommy, is his best friend. He says, Tommy, I've got to appoint you as my independent trustee because I want to take this trip. I'll appoint you as trustee. Can I have the money? Tommy says, sure, let's go. He gives him the money. All right. So he's compliant with the terms of the trust. So Thomas J. Henry sued him again for this car wreck. And then your son says, I can't pay you because I can't get it except for my needs. And Thomas J. Henry's going to say, have you ever taken money out of this trust just because you wanted it? And your son's going to say, well, as a matter of fact, I did. But I had to appoint an independent trustee to do it. Okay. And so let's appoint Tommy and let's see if he'll give you Thomas J. Henry the money. What's Tommy going to say? No way. So what's Thomas J. Henry going to say? He said, Tommy, that's your best friend. What do you think he's going to say? Let's pick another trustee. So your son said, well, we got to pick another independent trustee. Let's see. How about Chase Bank? Who has a fiduciary responsibility only to your son to preserve those assets. If that's Chase, that they'll give Thomas J. Henry money. What are they going to say? No way. So you've got the built-in asset protection. So that clause in your trust is set up that particular way where the beneficiary can get money out for their lifestyle. But if it's beyond their lifestyle, they have to appoint an independent trustee. If it's always within their lifestyle, they never have to appoint the independent. That's why it's in there.
Okay, but that's in our trust that says that clauses there that permits only lifestyle unless you pick another trustee.
That's right.
And that's in our.
Yeah.
But it's only for the kids, it's not for you.
So you can take it up for anything you want.
It's for when you're gone.
Yeah.
What is there, we will stick around as long as you want us to stick around, but I'm cognizant of time and I know it's.
Was this helpful?
Yes.
Yeah.
Was good. No. We haven't done it in a while, and we decided it was time to do another.
And we're always taking recommendations. If there is a topic that you want to know more about, we want to do more of these. And so we are open to suggestions. What do you want to know about? And we want to be there for y'all. So
We're meeting this once a year.
once a year, really? Okay.
Because I've been with this, a couple of months before, and it's just like, it's reinforcing.
Well, you're giving the next one.
Yeah, cookies.
Yes,
We're gonna have.
yes, sir.
So my mom is your client.
Yes, sir.
Her trust, and I'm a co-trustee with her, but I'm also the successor trustee. So when she passes away, and I call you guys up, do I then become their client? And
Yes, sir.
Yeah, you become the successor trustee. So you have two hats. Right now, you get a co-trustee head. When she passes, you take the co-trustee head off, and you become a successor trustee.
But you have, if, that, I'm saying, you've done your estate planning with another firm. We represent you only in the sole capacity of your role as trustee.
Well, thank you all for coming.
Thank you.
Thank you.
We'll stay around if you have any questions, we can sit around for a while, but I'm glad, we hope you learned something.